Please be seated. The court is now in session. As the President of the Trial Chamber and on behalf of the bench, I would welcome all parties to the proceeding, including the prosecution, the lead co-lawyers for civil parties, the co-defense lawyers for the defense teams who are present today. The Chamber holds the hearing today in order to hear the submissions and observations by parties to the proceeding as the consequence and effect of the decision on the co-prosecutor's appeals against the severance order and the scope of case 002/01. By the Supreme Court Chamber, dated 8 February 2013, document E163/5/1/13. This is in order for the trial chamber to get all the opinions so that it can form a decision regarding the scope of the proceeding in case 002/01 so that we can expedite the proceedings. I would like now to declare the proceeding opened. All parties are also reminded that during today's proceeding and during this week's proceeding commencing from today and on the subsequent days next week, Judge Cartwright has some personal businesses so that she cannot participate in the proceeding. After through consultation with all the sitting judges of the trial chamber, we decided to appoint Judge Fans, the reserve international judge, to replace Judge Cartwright during her absence until such time that Judge Cartwright returns to take her usual position at the trial chamber. This is based on the Rule 79.4 of the ECCC internal rules. Mr. Evidentiary, could you report the attendance of the parties and individuals to today's proceeding? Evidentiary, Mr. President, for today's proceeding, all parties to this case are present, except the accused, Ieng Sari, who is present in the holding cell downstairs due to his health reason. The accused Nuon Chea is absent due to his health reason and is being hospitalized at the Khmer Soviet Friendship Hospital. However, through his counsel, Nuon Chea confirms that he does not object to today's proceeding as long as he has the opportunity to take consultation with his defense teams before responding to the submission by the prosecution. Khieu Sampon states that he does not intend to participate in today's proceeding. However, he requires to participate tomorrow. The National Defense Council, our dom for Mr. Ieng Sari, is absent today. President, thank you, Mr. Dutpari. Noon Chia's defense, do you have any matter to raise before this chamber?
Thank you, Mr. President. Good morning, Your Honours. Good morning, Council. Our client has indeed agreed not to object to the continuance of this very important hearing today. However, because today's submissions and arguments are so fundamental to this trial, he has only agreed to waive if we, as his counsel, can properly brief him about today's submissions. And receive, of course, instructions after our consultations. So before we can give our submissions, not today, tomorrow we would like to give them. So we need to speak to our client first in order to be able to properly advise your court. Thank you.
President, thank you for your information. International Council for Khieu Samphan, you may proceed.
Thank you very much, Mr. President. Good morning, Your Honours, and good morning to all parties present. To supplement what my learned colleague has just said, I wish to emphasize one point concerning the exchanges that we can have with our client up until this morning, and to this very moment that I am stating this, we are still unaware of the position of the co-prosecutors in response to the questions being put by your Honourable Chamber, nor are we aware of the position of the civil parties. However, what is of crucial importance is that we have time to reflect and contemplate with our client before the co-prosecutors submit a very clear request concerning the expansion of the scope of this trial. We would therefore hope, and I believe that this is a shared desire, to be able to consult our clients and discuss this very important issue. This is equally important since, Mr. President, you have asked us to comment on how these proceedings will be scheduled and organized. We believe that it would be much more logical to, rather than solicit the opinions of all parties, as far as Khieu Samphan's defense is concerned, we would prefer to have an overall view and take a circumspect position on all of the positions to be expressed, particularly by the co-prosecutors, and then discuss with our clients these matters and make very clear before your Honourable Chamber our stance and position. Those are my comments, Mr. President.
President, thank you. The trial chamber would like to inform the parties and the public that on Thursday, the 7th of February 2013, the chamber informed the parties and the public that we will not hold the hearings between the 11th to the 15th of February 2013 due to the health issue by the accused Noon Chia, who has been treated at the Khmer Soviet Friendship Hospital, and we actually scheduled to hear the witness Elizabeth Baker this week. And due to the continuing health issue by Noon Chia, and as he is being treated at the moment at the Khmer Soviet Friendship Hospital, and in conjunction with the decision by the Supreme Court Chamber regarding the co-prosecutors' appeals against regarding the scope of the 002/01, and taking into account the concerns of the effect of that SCC's decision, we have to reschedule the hearing of the testimony of the next coming witnesses or experts. And the trial chamber is facing with the effect of this decision, so that we have to deal with this issue principally first, because it is the most urgent matter that we have to deal with. For that reason, we issued our memo dated 12 February 2013 by instructing all parties to provide their comments regarding the 9 points stated in paragraph E of that document, that is E160/3/1/13/1, so that the Chamber can issue another decision regarding the scope of case 002/01 with sufficient basis and grounds, which shall be consistent with the SCC's decision and their direction dated in that decision dated 8 February 2013, as well as all the briefs and submissions by parties. In our Memorandum of Understanding, we intend to hear the comments and submissions made by parties in case 002 regarding the effect of the SCC's decision on the co-prosecutor's appeals regarding the scope of case 002/01 and the severance orders by the trial chamber. And it is planned, in fact, for the 14th and 15th last week. However, due to the inability of certain parties to this case, we decided to hold the hearing today, and if it doesn't conclude, then tomorrow. Upon seizing of the case 002, dated 9 September 2007, by the virtue of the pre-trial chamber who rules regarding the appeal against the closing order by the accused Ieng Sari, Ieng Thirit, Nunchi, and Khieu Sampon, and after the conclusion of the initial hearing in 2011, and pursuant to Rule 89 ter of the internal rules, on 22nd September 2011, the trial chamber issued a severance order in case 002. So there will be separate hearings by focusing on particular portions of the indictment. In each segment of the trial, there shall be a judgment and a conviction if the accused found guilty. That is document E1 through 4. Also, on the same day, in its press release, the chamber stated that the trial proceedings at this sheer scope and complexity, and due to the advanced age of the accused in case 002, which have been the experience in various other international tribunals, could last for at least 10 years. And if there is no severance order, the hearing in at this magnitude will last that long. Please refer to that information. For the first segment of the trial in case 002/01, we determined the scopes of the facts, including the historical background of the Communist Party of Cambodia, the communication, the military structure, as well as the facts concerning joint criminal enterprise and the applied policies on the forced transfer. These are the crimes charge concerning the forced movement phase 1 and 2, as well as the role of the accused. And as for the law, the crimes charged are crimes against humanity, including 6 points, murder, up to the forced movement phase 1, mass killing, limited to phase 1 and 2, political and all other inhuman acts which has the impact on the human dignity, as well as the political persecution limited to the forced movement, and other inhuman acts within the limit of the forced movement phase 1 and 2, and number 6, the forced disappearance limited within phase 2 of forced movement. And then the forms of responsibility and the characters of the accused. Please refer to document E124/7.2, which is an annex to the severance order in case 002/01. Upon seizing the notification of the severance order decided by the trial chamber on the 3rd of October 2011, the co-prosecutors submitted through the trial chamber to reconsider the severance order and request for the amendment to the severance order so that the trial chamber is requested to include certain crime sites within the scope of case 002/01. The co-prosecutors raised various reasons, namely that the severance order by the trial chamber is not in the interest of justice because the crimes selected for the prosecution in case 002/01, as claimed by the co-prosecutors, which is likely to be the only trial in case 002, does not reflect all the crimes charged in the indictment. Please refer to document E124/1 and E124/2. On the 18th October 2011, the trial chamber rejected the request for the reconsideration by the co-prosecutors, and the reason that we gave is that we would consider the ability to request for other facts if considered necessary by the trial chamber. Document E124/7 on the 27th October 2012, the co-prosecutor requested for the expansion of the scope in case 002/01 by inclusion 3 crime sites out of those 9 crime sites, namely the killing site at District 12 and at Tulpu Tray, and the security center of S21, including June 8 killing site, as well as the purchase from the New North from the center zone and from but it does not include the Preso work site, that is S24. Upon seizing the submission by the co-prosecutors, the trial chamber invited all parties to case 002 to provide their oral arguments in the trial management meeting on the 27th of August 2012, and on the 8th October 2012, the trial chamber issued its decision to reject the request for the expansion of the scope in case 002/01 by the inclusion of the killing sites at District 12 and Security Center S21, but agreed to include the killing sites at Tulpu Chre, as it is of the view that the killings happened immediately after the forced evacuation of people from Phnom Penh, which was part of the forced movement phase 1, and it amended the annex to the severance order document E124/7.3, in which it states the facts as alleged by the inclusion of the killing site of Tulpu Chre. As for the law, it included the killing at Tulpu Chre as well, and the political persecution was also included for the Tulpu Chre killing site. On 7 November 2012, the co-prosecutors lodged their immediate appeal against our decision to the Supreme Court chamber, and the Supreme Court chamber subsequently made their decision on 8 February 2013, in which it decided to accept the immediate appeal by the co-prosecutors pursuant to the relevant internal rules, and it declares the invalidity of the servants of Case 02 and announced the impugned decision. However, the Supreme Court chamber gives their direction in parts of its decision, in particular in paragraph 50, which opened the way for the trial chamber to reconsider the severance of Case 02 pursuant to Rule 89 ter of the internal rules. It also directs the trial chamber in principle that it should do so appropriately. I would like now to give the floor to all the relevant parties so that you can make your observations and give your positions regarding the 9 points as we raised in our memorandum, in particular in paragraph 3, as well as various other requests concerning this very subject matter. And as we already notified the parties in our notification that today's proceeding will be of the oral arguments raised by the co-prosecutors and by the lead co-lawyers as raised and indicated in our memorandum, and all parties are given the opportunity to make their brief response. And then the defense teams will be given the opportunity as well to present their understanding and position, and other parties, including the prosecution, will give the floor for their brief remarks and response. To start with, the floor is now opened and given to the co-prosecutors to respond to the questions that we put to the co-prosecutors and the lead co-lawyers. The question is,
the trial chamber severance order and related decisions reflect the concern that the entirety of the charges in the Case 002 closing order are likely to be able to be tried within the accused's likely lifespan or before they become unfit to stand trial. So what are your views on these concerns? President, I learned that there was no translation just now. I did not know when the translation paused, but court officer, can you please check with the interpretation booth? The President, court officer, it is not an issue with the translation. Actually, it was confusion. I did not see the interpreters, liaison interpreters who were supposed to sit behind the bench. Now I hand over the floor to the prosecution. You may proceed.
Yes, thank you, Mr. President. May I make a suggestion which I think will actually expedite this process? Rather than going to one question and getting the submissions of all of the parties on a single question, and then moving to the next question, might I suggest that we address all of these issues together? Because I think they are all interconnected. And I genuinely believe that actually we certainly can move through this much more quickly if we address all of these questions, as opposed to going one question after another, which I think will take a considerable period of time.
The President. The Chamber wishes to advise the prosecutor that the Chamber has outlined 9 issues for parties to respond, and this was sent to all parties well in advance, and the Chamber has discussed this matter amongst the judges of the bench, and we believe that this outline was meant to ensure that the opinions and views of parties are comprehensive and complete. That's why the Chamber is of the opinion that the direction to the parties to respond to these nine issues will be beneficial for the Chamber to issue a new decision better, and the Chamber views that the upcoming decision to be issued by the Chamber will not be criticized or plunge into any problem. So for this reason, the Chamber directs that the party respond to the 9 questions outlined by the trial chamber as per the memorandum of the trial chamber dated the 12th of February 2013.
Just to clarify, Mr. President, in case there's any uncertainty, of course, yes, we are going to address the 9 points that you have set out in your memorandum, but we believe that it's a much more efficient use of time that we do that together in one group, and we will use considerably less time than if we're getting up and down to answer each question. And that's certainly what I understand you're saying, is that that's what we can do to address all of the 9 points. Yes, we will do that.
The President. Thank you. I hand over the floor now to the defense lawyer. You may proceed.
Thank you, Mr. President. Good morning, Your Honors, and good morning to everyone in and around the courtroom. Setting aside efficiency, which I do agree is a consideration, and in fact what is being proposed is efficient. The prosecutor would go on and address all 9 points. Then, because we have our own respective clients, some who are not here, some who may not necessarily be able to follow the proceedings, we need to consult with them. We need to make sure they know what the prosecution's and civil parties' position is, and after that, we can respond. So based on what the application made or the submissions made by both the Nuncia and Q-Sampon team, and based on our clients' state of health as it is, and if you see today, the doctor said that he's having problems following the proceedings, we think it is highly useful for the prosecution to address all 9 issues along with the civil parties, allow then the defense to consult with the clients, get instructions, and then respond. After all, we cannot go forward without receiving instructions from our clients. Thank you.
The President. Yes, civil party lawyer, you may proceed.
Thank you, Mr. President. Good morning to everybody. We would agree with the prosecutors. We will answer the 9 questions that have been put to us by the Chamber, but we do think that it would be simpler to answer in one go. Firstly, the prosecution, and then for ourselves. That way we respect a kind of consistency, and of course the questions are linked, so the answer to one leads into the answer to the second. So that is the way we would propose that it be done. Thank you.
The President, I hand over to Judge Fence in order to clarify this in case there has been any issue with translation.
Yeah, apparently there has been a translation issue. What the President says and what the Chamber has decided is that we stick with the original order of questioning and answer as outlined in the memo. That means first question, prosecutor answers, floor is given to co-lead lawyers, we proceed to the next question. Now, shortly to the reasoning. We agree with the prosecution that all these questions are interlinked, but this memo is designed along the reasoning in the Supreme Court decision. This is basically what the Supreme Court thinks we need an answer for to make an informed decision. We wish to avoid that these issues are finally somehow glossed over with and some unclarity as to what choices party wish to make or wish the Chamber to make remains. For this reason, these very pointed questions and the need to get an answer to these questions. So to repeat, we stick with the original order as it was outlined in the schedule.
Prosecutor Chilian. Good morning, Your Honors, member of the bench. Good morning, parties. Good morning, members of the public in the public gallery. I thank you, Your Honors, for granting us the floor to address to you today and the invitation of the Chamber concerning the implication of invalidity of the severance of K002 following on from the Supreme Court Chamber decision of the 8th of February 2013. Your Honors have requested to hear our views and those of other parties on a number of issues. The Chamber, the prosecutor will recall some of the decision leading to the decision of the Supreme Court Chamber. The decision of the Supreme Court Chamber makes fundamental findings on matters of legal principle, but it is important to emphasize that the consequences of its decision are actually quite simple and need not cause undue delay to these proceedings. This is why we are particularly grateful that Your Honors acted so quickly to convene these hearings. There might have been some misunderstanding as to the effect of the Supreme Court decision. That's why, to begin with, I would like to emphasize a point for the public, that the decision of the Supreme Court Chamber does not invalidate the entire proceedings in Case 002. The time that has been spent and the evidence that has been heard so far has not been vested. The President, Prosecutor, please pause because I know the Defense Counsel is on his feet. Counsel Kanavas, you may proceed.
Thank you, Mr. President. I assume, based on the court's directions, that we're going to go one by one on the questions. Now it appears that the prosecution is giving either an opening statement or commenting. I assume that we may have an opportunity at some point, but we need clarification. Is the prosecution going to be commenting on the decision, or are they going to be answering the questions? Because the memo is quite clear. You want to hear certain questions. I don't think the trial chamber needs, at least at this point, an analysis of the decision. I mean, either way, it doesn't matter to us. But I thought that was the purpose of saying go down the questions when you called upon the prosecution. So perhaps we can skip the speech and get to the answers to the questions. Thank you.
Co-prosecutor, Mr. President, I'd like to clarify on this point. To start with, I will give some background as to what has led to the appeal, and my colleague will respond through the points raised in your memorandum, point by point. So this does not mean that we will not abide by your instructions, Your Honors, but at least we should understand the background of that decision. President, thank you, the co-prosecutor. Could you please make a brief presentation regarding the background, as the essence of what we want is your response and other parties' responses to all the 9 questions that we put to you as a consequence of the decision by the Supreme Court chamber, as it will have great impact on the proceedings being carried out by the trial chamber in case 002/01. If there were no impact, we would not conduct this hearing today. Co-prosecutor, thank you, President. And of course, the background statement that I make is brief, and we will take our time to respond to your questions point by point. Allow me to continue, Mr. President. The Supreme Court decision requires Your Honors to correct the way in which the severance of case 002 has taken place. In fact, it is not a matter of what was done, but how it was done. At this time, these proceedings still rest on the whole closing order of 16 September 2010. Following on from this hearing, this trial chamber will make another determination on severance on what subject matter should form part of these proceedings. The anticipation is that the hearing of evidence in case 002/1 will come to a conclusion this year, followed by judicial determination thereafter. I should like to set out the co-prosecutor's consistent position on the severance of case 002 by referring to the manner in which this issue has unfolded over the past 16 months. My fellow international co-prosecutor will then address you on the pragmatic requirement of serving the case once again and put forward our concrete recommendations in this regard. In essence, Your Honours, the Supreme Court Chamber has directed at paragraph 50 of its decision that the severance of case 002 can be based on one of only two possible objectives. One, to effectively manage a complex multi-accused case by splitting the charges into multiple stages of trials planned in advance. And two, to accept that the deteriorating health of the co-accused and the interest in reaching a final verdict in these proceedings require that a set of representative charges be heard, while others, however regrettably, indefinitely stayed. This is the pressing decision before Your Honours, having heard the views of the parties both today and tomorrow. Your Honours, since the severance order of 22nd September 2011, the co-prosecutor's consistent position has been and remains that severance of case 002 is in the interest of justice. We have never opposed severance of this case. We have simply objected and tried to be heard on the form of the severance. 11 days after your order of 22nd September 2011, we requested that you respectfully reconsider its terms concerning the sequencing of specific charges and the choice of crime size, while fully concurring with the imperative of severance. We asked Your Honours to consider a more representative set of crime size, that is 9 sides in addition to phases 1 and 2 of the forced movement, and charges encompassing a broader range of crimes against humanity that more fully reflect the implementation of the 5 policies of the joint criminal enterprise identified in the closing order. An internal review at this stage led to the difficult decision to not request the priority consideration of genocide and also war crimes charges in case 002/01. The co-prosecutors considered at the time that judicial consideration of these 9 additional sites would have satisfied the international standard of representativeness of the totality of the crimes charged and would have safeguarded the important objectives of the agreement between the United Nations and the royal government. Although our request to reconsider the sequencing of specific charges and the choice of crime size was denied, Your Honours acknowledged that you would be guided by the co-prosecutor's views in expanding the scope of trial. And that is entirely proper. The trial must be fair to the co-accused, but the co-prosecutors bear the burden of proving the case against these three elderly defendants. To adduce evidence piece by piece takes detailed planning to avoid redundancy or repetition. To rebut evidence with candor and conviction is no less important to the fairness of these proceedings, but does not impose the same positive burden. In January 2012, as the trial progressed, the co-prosecutors requested Your Honours to include just 3 of the original 9 crime sites we had requested. This request was opposed by Ieng Sari and Khieu Sampon. Our request was considered and left open. Your Honours stated at the time that the Chamber, quote, may on its own motion decide in due course to extend the scope of trial in case 002/01 in exercise of its trial management discretion, end of quote. A further 8 months passed, and on 3rd August 2012, in preparation for a trial management meeting, Your Honours indicated that the Chamber, quote, may be willing to compensate a modest extension, end of quote, to include executions of evacuees at District 12 and of former Lunol soldiers and officers at Tulpu Chre, and crimes committed at Security Center S21 and the related execution site Chiang 8, and invited specific submissions on this point. Your Honours found reason to agree with the co-prosecutors that the addition of these proposed additional sites may be in keeping with the chronological and logical sequence of events to be heard in case 002/01. In advance of the trial management meeting, the co-prosecutors notified the trial chamber that the inclusion of crime sites at S21, District 12 and Tulpu Chre would significantly assist the co-prosecutors to meet their burden of proof by providing strong evidence of the criminal intent behind the forced movements of the population. We were the only party to submit written positions in advance of this meeting. We did so in the interest of fairness and transparency to ensure adequate notice and time for preparation for all parties. We indicated that witnesses relevant to this size would need to be heard by the Chamber in any event as part of the co-prosecutor's proof of the true purpose behind the 17 April 1975 evacuation. This position was reiterated 2 days later, that is, at the trial management meeting itself. Your Honours seem to have disagreed with these arguments in favor of the inclusion of S21 and District 12, while finding a reason to include killings of Lunol soldiers at Tulpu Chre. The Chamber disposed of our request of 27 January 2012 by Your Honours' Memorandum of 8 October 2012 after a lapse of more than 7 months. 11 days later, the parties were conclusively advised that no further extensions of the scope of trial in case 002/01 would be entertained. It was in this context that the co-prosecutors considered that recourse to appeal was necessary. Our assessment at that stage reflected, in substance, the second of the two options put before Your Honours by the decision of the Supreme Court that only one trial was likely to take place in circumstances where the fixed scope of trial would not be reasonably representative of the charges in the closing order. Once again, I am grateful to Your Honours for entertaining this brief review of the procedural history regarding the issue of severance in case 002. We believe it is important for both the trial record and for the public to know of the actual circumstances which have led us to this point. I ask that my fellow co-prosecutor be permitted to address you on the way forward from here. And the request by us regarding the expansions of the crime size, I am grateful, Mr. President. President, thank you. The international co-prosecutor, you may proceed.
Thank you, Your Honours. The way that you've structured this is going to mean that certain questions have very, very brief answers because, frankly, the answers are self-evident from the question. So I'm not going to labour points where the answer to the question is absolutely obvious, and that's why I was making the suggestion earlier to try and save some time, but as you wish. The first question, our views on whether or not it's likely that the entirety of the charges in Case 2, in the Case 2 closing order, will be tried within the accused's likely lifespan or before they become unfit to stand trial. I think you will find, if you look at the record of these proceedings, that we have consistently taken the position that it was highly unlikely, intangibly remote, that these three accused would be tried for all of the charges in Case 2. So we agree with that concern. The reason that we're all here today has actually not anything directly to do with that concern. It's to do with what kind of case these individuals would be tried for. That has been our concern. We don't disagree with this proposition. We simply disagree with this trial chamber about the scope of the case that they are confronting, because we believe that this will be the only trial and that within that trial there should be a reasonably representative sample of charges and crime sites. But the answer to that question, you don't want me to talk about that now, you want me to talk about that later. So those are the very limited submissions. I think it would help, Your Honours, actually, for the purposes of the public, to do one thing very briefly, and that's to actually set out, because nobody's said it yet, what the central guidance of the Supreme Court chamber was. And I can do that in about 45 seconds. The direction that they provided to this trial chamber when adopting severance was this, that the trial chamber must be clear about whether it's adopting severance, A, in the interests of judicial manageability of multiple trials, so several trials, or B, because there will only ever be one trial owing to the deteriorating health of the accused. Now, whichever one of those two options you adopt and you choose has clear consequences for the chamber. If you go with option A, of multiple trials, the Supreme Court chamber has directed you to come up with a plan, to tell everybody, the parties, how we are actually going to do that. And again, I know you don't want me to speak about what the problems are, you want to talk about that later, but you have to understand that all of these issues are linked. They're not singular issues. You've got to look at this thing as a whole. Now, secondly, if you go with option B, which is a single trial, owing to the deteriorating health of the accused, and this is absolutely fundamental here, you must ensure that there is a reasonable representative standard within that trial. And in fact, the Supreme Court chamber has directed you to look at international standards on this issue, because in other international criminal courts, in the ICTY, the ICTR, the guidance is much more substantial on this issue. So representativeness is absolutely critical. It's at the heart of why we are here. So those are my submissions on the answer to the first question. I'll have more to say on all of these issues as we go along. Thank you.
President, thank you. The floor is now given to the lead co-lawyers for civil parties to respond to the first question. You may proceed.
Mr. President, Your Honours, as Madam Co-Prosecutor has done, I wish to take a few moments prior to responding to the first question to outline some of the issues that the civil parties have identified with respect to the severance order. We cannot fully understand a proper response if we are not to fully grasp all of the issues, matters driving our position. It is most regrettable that we were not able to hold proceedings or debate prior to the severance order. The time has come now, and I would simply wish to recall a few points, and then we will proceed by answering each of the 9 questions as per the request of your Honourable Chamber. These 9 questions do not constitute the issues, the problems that the civil parties have identified with respect to the severance order. I would call your attention to paragraph 4 of the memo of the 14th of February, since we believe that there are other correlated problems that stem from the severance order. I will not address them now, as it would be more timely to address them following these proceedings. The decision of the Supreme Court chamber highlighted a certain number of matters which were all unequivocally addressed in the submission of the civil parties 16 months ago. On the 18th of October 2011, all of these matters were addressed and must be responded to by the trial chamber today. Some of them have been encompassed in the 9 questions. Other problems will be addressed at a later date, and I would wish to expand upon them. I would also add that in an ideal world, the civil parties would have liked to see all of the facts of this case examined. How could it not be otherwise? On many an occasion, we have been able to call to your attention the diversity of civil parties, which is not surprising given the magnitude of such a trial concerning mass atrocities and crimes. They concern members of religious orders, intellectuals, soldiers, merchants, workers, peasants, the Vietnamese, victims of specific crimes such as forced marriage, for example, as well as Khmer Rouge, who were victims of major purges. The victimization is quite varied. How could we not want to see each and every one of these victims have the facts tried, the facts which have caused their harm? How could one not expect that each of their judicial expectations for justice to be done, for the fight against impunity to be fully carried out. The civil parties obviously want to see exhaustive examination of all of the fakes, and it is our duty to call to your attention this imperative. However, today, it is not possible to proceed as if the preceding 16 months of trial have not occurred. Over the course of these 16 months, we have received some answers, some of them implied, some of them explicit, some of them absolute. We have also heard from witnesses, experts, as well as civil parties summoned before this chamber, and they were summoned based on a confined trial dealing solely with forced transfer. Certain documents were adduced and tendered, and yet we were facing restrictions because of the health conditions of the accused and their advanced age. Their health had deteriorated to the extent of having an impact on the proceedings. Since 2012, trial sittings have been reduced to 3 days a week. To try the totality of crimes and fakes would not only extend the proceedings because of all of documents to be introduced and all of the witness testimony to be heard, but that could also very well compromise the work that has been done to date. The trial chamber is entirely correct, as stated in paragraph 3 of its memorandum under point 6, to emphasize that the expansion of a trial scope would necessitate the recall of certain witnesses in order to re-examine certain documents. This strikes us as entirely impossible given today's circumstances. The decision of the Supreme Court chamber, while it contains very relevant grounds, and while it correctly raises legal issues that the civil parties have already addressed, comes far too late, as it simply annuls, pure and simply, the severance order, a request that was not even made by the co-prosecutors. By arriving at such a late point in time, this decision, in the view of the civil parties, loses relevance and renders part of the decision too abstract to fulfill the expectations of the civil parties. It is impossible to cover the totality of crimes and facts. And as far as we are concerned, the civil parties believe that we are not dealing in a purely abstract or academic trial, but rather a trial that has been ongoing for the last 16 months, which has very concrete objectives. We will be providing answers to your questions, which you will also hear in conjunction with 3 additional points. We are guided by this reality, as well as a very obvious pragmatism that stems from the previous 16 months of proceedings, which is driven by what has been said not only by the witnesses, civil parties, or witnesses, but also stated very clearly by all parties and your Honourable Chamber. It is for that reason, and this brings me to my concluding remarks, we will not be seizing today's opportunity to reopen a brand new trial to try all of the facts. This does not serve our interests. In fact, it is counter to the interests of justice and certainly counter to the interests of the civil parties. I simply want to impress upon you that the civil parties will certainly embrace an approach that is reasonable, that takes into consideration all that has been achieved in this trial and in the proceedings to date. I thank you, Mr. President, and Your Honours.
The President. Yes, you may proceed, but please respond to the question specifically. Because now the Chamber needs to take serious consideration, and we need the matter to be addressed as specifically as possible so that we can address the issue objectively. That's why the Chamber has directed the parties to respond to the issues and express their views on the various issues put forward by the Chamber. Council Pik-ong. Thank you, Mr. President. Good morning, Your Honours, and good morning to members. I would like to respond to each and every question outlined by the Chamber. The first question concerns the concerns that the entirety of the charges in case 002 closing order are likely or unlikely rather to be able to be tried within the accused likely span or before they become unfit to stand trial, and this is our joint concern. We are very concerned that this is an issue. So I would like to share our concern with the Chamber. We are worried that the accused might not stand trial until the conclusion of trial, so I also suggest that the Chamber consider the appropriate scope in the first trial. The President. Thank you. The time is now appropriate for adjournment. The Chamber will adjourn now until 10 to 11. The Court is now adjourned.
សូមក្រោកឈរ